Mr. Caceres, you are in front of us now because you have a fugitive case. You are wanted out of state of Connecticut for sexual assault. And he is already waived.
Yes, Judge.
And where are we at now?
So, Judge, this was originally set today, but on Friday, on a notification from the demanding jurisdiction, they requested an extension from today to the 3rd. They didn't receive notice, which I don't believe this was addressed on Friday, but they've since corrected the issue with the original fax number not reaching the detective's desk for extradition. And so they've now corrected it where this won't happen again.
So are you saying?
Right out of the gate, this isn't just a marijuana possession hearing anymore. The judge is shifting from punishment to a reality check. Notice what he's doing here. He's less concerned about the charge itself and more concerned about the defendant's future. Some viewers might think this sounds harsh, while others might see it as tough love. What do you think? Is the judge crossing a line, or is this exactly the kind of wake-up call someone in this situation needs?
On the phone, when they were notified that same day, within, I would assume, a couple of hours, because it was still the morning, the detective immediately called Amy, who then notified me, and I talked to the detective within hours of being notified. And from then, they asked an extension to the 3rd to pick him up. For this offense, they have been investigating since 2021, and the warrant issued in 2022 is that they've been pursuing this defendant for quite a long time. And again, this was learned after our approach. I'm speaking with the detective, is that they weren't aware. They had a possible suspicion he might be in Texas, but they weren't even aware he was here. But due to the severity, the nature of the offense, where, to recap Friday, is that this was closer to a burglary or habitation first degree, where sexual assault was committed after forcing himself into the home of someone that he knew. This was not from what they allege, it's not a dating relationship, but someone he's familiar with, is that because of the severity of the offense and the fact that the warrant is so old, is that the detectives believe they are not confident that he will self-surrender. And because they've already confirmed, and they sent another confirmation email this morning that they are able to secure and pick him up this Friday, is that we request no bond for this offense and the extension.
If I may, so whatever the charges might be, it could be murder. It can't be murder because you can't let him out on bond. The point is he's presumed innocent. So without anything else, he is innocent as he stands here. No evidence is being presented. So if we're talking about the severity of something, he is presumed innocent. He is innocent of that as of right now. Until he gets over there to that jurisdiction, can they find him guilty of that? So presuming he's innocent, talking about the severity of a charge doesn't really have an effect on this fugitive case, because there are two things that he's got in place, two things that he needs to make a decision on, whether to waive or whether to fight formally his extradition. The waiver says what he agreed to.
This is one of the most important moments in the entire hearing. The judge isn't talking about today's sentence, he's talking about long-term consequences. A criminal record can affect employment, housing, loans, and opportunities years down the road. What's fascinating is that the defendant still appears relaxed, while the judge is describing life-changing consequences. Have you ever seen someone underestimate the seriousness of their situation this much?
Number, you get to hold him 3 extra days. This says 14 days. This is what he signed up for. This is what's ordered. This is what I say should stand, and this is what I say should allow him to get out today. If they didn't do their due diligence for this, it's not on my client. He signed up for this.
So let me explain to you how things work, Mr. Caceres, is that the 14 days is a courtesy. Statutorily, by statute, we can hold you for 30 days. Normally, and it has become custom that we do 14 days because of the overcrowding that we have in Harris County. We have so many people in custody, 8,000, 9,000, up to 10,000 people at any given time in and out of our jails. And because of that, as a courtesy, we do 14 days. Now, many times I grant extensions, I don't grant extensions. A lot of times there are several factors that is determinant of whether I grant an extension or not. One of the things are, has there ever been an extension before? Number two, the nature of the charge. Number three, have you ever had a fugitive case before? And so these are things that I look at as to whether to grant an extension or not.
Your Honor, may I please speak?
Well, I don't know. You may want to talk to your lawyer. The thing is this, look, I don't want you to talk about the original case, okay? Because the thing is that I live stream these proceedings, right? And so I don't want you to say something that you put your foot into your mouth, because here, the only thing that we're discussing is whether I should set a bond for you to get out, for you to go turn yourself in. That warrant, even if I let you out today, that warrant will eternally be there, and it'll always be out there until you go turn yourself in. The only thing we're discussing now is whether I should set a bond to let you go turn yourself in. And I don't know, because are you a flight risk? I don't know. The only thing I know is that you're charged with a very serious case. It's sexual assault. And so to me, the protection of my community is paramount, number one. Number two, the other question I have is, if we let you out, are you going to go turn yourself in? Everyone tells me that they're going to go
I
do
have
that.
my family sitting in court, and they are the one supporting me. And I know 100% they're going to support me to turn myself in. That's why they're still here, and I'm still the last one. And yes, I didn't know about the fugitive warrant that I had. And yes, I'm willing to turn myself in because I'm innocent.
You need to fight those charges regardless, because they're very serious charges. So Dave, what day did you say that they're going to pick
It's
up?
Friday, and I forgot to include, I know typically the court permits over objection for the 3 days, but considering the New Year's Eve is holiday, that's how I also included the.
So are they going to be here Thursday and we reset to Friday?
On Friday. And so that's why the discussion on last Friday was having it on the 6th, but if they're not here by Friday morning, is that you would potentially grant a bond.
So this is what we had planned to do, was I was going to give them an extension until Friday morning, right? If they don't come by Friday in the morning, I'm giving you a PR bond.
I came to visit my family for the holidays. I wasn't able to enjoy that. I'm willing to turn myself in, but I would like to be with my family for the New Year's to start with a strong.
Concern is not my concern. And my only concern is I want you to get back to Connecticut.
And I will, but I need my family. I need to today, as the paper says, I signed for 14 days, and I would like to have a time with my family to look for the bond, to look for them to go forward with turning myself into Connecticut, but not like waiting for Friday.
Let me make one thing clear to you. This isn't about giving you a PR bond. If I were to set you a bond now, it's going to be something substantial, meaning a high bond into the 5 digits to ensure that you go back to Connecticut. This isn't about giving you.
And just like that, the tone of the courtroom completely changes. Unlike the first defendant, who received a lengthy lecture about life choices, this case centers on public safety. The judge is drawing a hard line because this is now a second DWI allegation while already out on bond. From a legal standpoint, bond revocation is one of the strongest tools a court has to protect the community. The message couldn't be clearer. If the court believes you're a danger to others, your freedom can disappear instantly. Were these conditions justified, or do you think the judge went too far?
When we have fugitive cases, I normally set bonds, $5,000, $10,000. I've set bonds at $50,000. I've set a bond at $100,000, depending on the nature, severity, how many criminal history. So this isn't about just letting you out now willy-nilly. No, I would set you a bond, and it's going to be a substantial bond, because I have to know if I'm going to let you out, there's got to be enough blood in there that you're going to actually go back and not just try to flake out. Because if you take off and you don't come back, all that money's gone. So,
okay. But the 14 days were exactly what I signed for.
Remember, it is a courtesy. Statutory.